When a plaintiff prevails on securing a final restraining order, there is oftentimes a request for counsel fees. That request for counsel fees is not treated the same way as our other requests for counsel fees in the family part, in divorce, or in post-judgment divorce matters. Usually where there is a restraining order, the statutory basis for that is simply that there has been an injury to a party, and thus there is a right of restitution known as reasonable compensation. So as long as the legal fees are reasonable, the plaintiff is entitled to receive counsel fees. To the contrary, a prevailing defendant does not have the same entitlement to counsel fees. A prevailing defendant is entitled to seek legal fees, but only in the context of frivolous litigation. There is a statute and a court rule that governs when a party can seek legal fees as a prevailing defendant, and it's very uncommon that that occurs. So when a defendant wins, even though there may have been some failure to prove a case by the plaintiff, the court does not want to disadvantage true victims of domestic violence from coming back to court just because they could not prove on this instance that they have a predicate act that entitles them to a restraining order.